Hey, good Saturday afternoon. Carl Rominger here, coming at you live from the WHP 580 studios. 540-0580. 540-0580 is our talk line number. Feel free to give me a call here. And you got a legal question? Need to know the answers to a legal problem? Want to shout out about the Supreme Court extending the Second Amendment to the states? Want to talk about whether it's legal to kill Osama bin Laden? I don't care. Call in 540-0580 and we'll talk about it. I see a few calls ringing right now. Shane will have you screened and we'll get you on the air here shortly. In the meantime, go to weekendappointment.com where you can download your free will kit. I just had another one in the mail today, so I'll be working on that diligently. We'll call you. We'll get you in. And it's a free will done by a real live lawyer, me. So if you're a longtime listener and never have bothered to either update your will or at least have me go over your situation and make sure you don't need a new one, it's all part of the free will program. All you got to do is download the kit, send it in, and we'll look at it and go from there. 540-0580. Feel free to call in. Of course, Mark Virginis, my financial guru, will be joining us later in the show and then through the bonus podcast hour. Fred, you're on WHP 580 with Carl Rominger.
Yes, sir, Carl. I had to evict one of my tenants. And besides the destruction, ordinary destruction, they destroyed my furnace and pushed the furnace into a wall. It was like $3,000 in damage.
Okay.
I had a local officer come out, and he basically asked me if I had any proof.
Mm-hmm.
Doesn't the proof come under their tenant agreement?
Well, the short answer is, how do you prove that they did it? And I guess one aspect would be exclusive control of the premise, right? If they're the ones who have exclusive control. And you're saying a police officer?
Yes, local.
Yeah, well, for criminal matters, so you've got to prove it beyond a reasonable doubt. And the problem is anybody can enter anybody else's house and do something to it or vandalize it. And so the fact that somebody vandalized, let's say, a house you lived in doesn't mean you did the vandalism, even though you lived there at the time it happened. But in a civil court, if you sued them for a landlord-tenant issue, the judge would only have to conclude what's more likely than not. That's called preponderance of the evidence. So in a civil court, you could probably meet your burden.
How do I start a civil suit?
You go see the local district justice and you file a landlord-tenant complaint. Now, of course, little caveat here is if you want to keep their security deposit, you've got 30 days from the date of them leaving and giving a forwarding address to give them notice of the intent to withhold that security deposit, the reason why, and then you can use that towards the damages, plus you can sue them for the surplus.
Right. So I got to file a civil suit.
Yep.
For what was that again?
Landlord-tenant complaint at the district magistrate's office.
And they would know what to file there.
They have a landlord-tenant form they'd hand you to fill out. Also, if you go to weekendappointment.com under the real estate section, we have it as a download.
Okay, I think that answers my question.
All right, Fred.
Thank you.
Thank you. And don't forget, folks, if you're a landlord and you want to go after the tenant, you've only got 30 days from when they leave, and as long as you got a forwarding address, to give them written notification of the damages and your intent to withhold the security deposit. If you don't do that, can't sue them. Can't sue them for anything, basically. Steve, you're on WHP 580 with Carl Rominger.
Hi, Carl. I got a question for you. My father is very sick right now, and he has having some health problems.
Okay.
And before he got sick, I was put as executor of his estate, and also we put my name on all his bank accounts that he has that are active right now.
Okay.
And I went to the bank this morning. Well, actually, I talked to my brother out in California. What he wanted to do was he wanted to liquidate some of his accounts down to the point to where it's more manageable.
Mm-hmm.
He has quite an extensive amount of money. And he's saying, like, maybe have his accounts down and maybe like $50,000 or something like that instead of having what he has and putting it into a separate account. And I asked the lady at the bank about doing that. She says that I can do 50% of it. She says, since I'm half on his bank accounts now, but she says the rest of it, she says she doesn't think she can do that. And I have done this before at another bank where my mother gave me power of attorney, executive estate, and she gave me permission to remove money while she was living and put it into another bank account. I never really questioned that.
Yeah, if you have a POA, certainly can transact their funds. Technically, joint account, you should be able to move any amount. Now, the long and short of it, though, is that's not going to change. That's not going to change if your father dies within a year. That's not going to change the estate taxes.
Yeah, Yeah, he's going to probably. Yeah, they're probably going to want that now. In other words, this was done over a year ago. So this was done probably about a year and a half ago when I actually got put on his account. Is that still going to make a difference?
Well, usually, that's good. If you've been on for over a year, then usually we're going to assume that those are joint. The balance in that account is joint, and he's going to be taxed presumptively on one half of it.
Yeah, on that stuff. But do you think that's a good idea? I mean, putting that money into a separate account?
I don't think it makes a hoot of difference.
Because what I'm afraid of is I have a, I guess you can call him like a county, one of these people that works for the county that does like for older people, like
right.
Different things like that. And she had actually came into the house and actually told me that she was going to come in and actually take over all his bank accounts to control his assets if he had to go into a home.
Right.
Did you ever hear of such a thing?
Well, they may be afraid that you're going to try to withhold that money, so that Medicare would have to kick in.
Yeah, I think what she was more afraid of was the fact that I was going to get a hold of the money and spend all the money, and then when he needed the money wasn't going to be there.
Right, absolutely.
But I wasn't planning on doing that. But she was making that assumption when she came to my house and and told me about this and stuff. And I think it's almost illegal the way they act about this money, because if he didn't have any money at all, she would have never been there.
Well, and the short answer though is that the government certainly has a right to try to preserve that funding to take care of him, and so that it doesn't go on the taxpayer's back. Mm-hmm. One way you could do that is you could just go ahead and not remove all that money, make it clear that it's not your intent to do that.
Mm-hmm.
But that really probably what you're looking at doing is it's not necessary to move that money. If you're moving that money to hide it, then that's not a good thing.
Yeah.
Okay?
Mm-hmm. So you say just leave it there for now and just let it sit there for now and just be half.
Yep, because if he's really in bad shape, then nothing you're going to do is going to be legitimate, okay?
Yeah, because I'm afraid once I do that might send a red flag to them, and they might think I'm trying to hide all his assets,
right?
And something like that. But they can still come after you. I mean, they can go after the house. They can come after anything they want.
Oh, absolutely. All right, brother.
All right, appreciate it.
Thanks.
Bye.
540-0580. Skip, you're on WHP 580 with Carl Rominger.
Hi, how you doing, Carl?
Good.
A friend of mine, his daughter at age 17, was cited for underage drinking.
Okay.
And it was stated that if she applied for a driver's license, it would be suspended. It would be a 90-day suspension.
Okay.
Well, she never did apply for a driver's license. Now she's 27 years old, 10 years later, and she's applied for a driver's license, and they're saying that if she gets her driver's license, that it will be suspended for the first 90 days.
Right.
Is that correct?
Yeah.
I mean, 10 years later or 20 years later?
Yeah, they leave those suspensions sit there forever so that you can't just wait them out.
Oh, okay. So it would have been to her advantage to have gotten her license back then,
mm-hmm.
Went through the suspension of the 90 days, and then she would have been free and clear.
Right.
So that doesn't necessarily kick in.
Until you go get your license.
Okay, buddy. Thanks a lot.
The other thing, by the way, just a reminder, she can get that expunged off her record. It's not going to help her with her license, but it's probably been long enough that she can remove that off her record so it wouldn't show on her background.
On her driver's record?
It'll come off the driver's record, I believe, after the suspension served. But yeah, she can get it officially. She have to get it officially expunged, meaning it won't show up anywhere.
Okay.
Because right now, if I looked her up, I could find that she had an underage drinking. Not that she may care about it, but I want to make sure everybody knows any summary that's more than 5 years old now, and as long as you haven't been in trouble since, you can get expunged.
And how do you go about that?
Yeah, you got to come see a guy like me, and I file a petition at the courthouse.
All right, good enough. Thanks a lot.
Thanks, Skip.
See ya.
540-0580. When we get back from the break, I'll talk with Mary. Hey, good Saturday afternoon here. Carl Rominger joining you live from the WHP 580 studios. Want to remind everyone, of course, we'll be recording the bonus podcast starting at about 3 o'clock. And so we'll keep accepting your calls here at 540-0580 from about 3 to 3:45. So if you don't get through during the show, if you don't have time but you're driving and you want to ask something, and of course I'm going to have Mark Virginis along with me, who's my financial guru. So if you do have a financial question having to do with retirement, estates, investments, markets, things like that, he'll be available a little later here in the show. And I'm going to call him up during the next break and get him on with us here. And then he'll be through the entire bonus podcast hour. So make sure you call in. Mary, you're on WHP 580 with Carl Rominger.
Hello.
Hi, Mary.
I have a question. I'm in my, I just recently remarried and moved into my husband's house.
Okay.
And he owns the mortgage on it, and, he's the owner on it. And I was just wondering, if something happens to him, am I responsible for the remainder, of the mortgage, even though my name isn't on it? Or because I am his survivor and we each, we leave whatever to each other.
Right.
Do I assume the mortgage?
The short answer is no. You don't automatically assume the mortgage. If he leaves it to you, okay. Mm-hmm. If he leaves the house to you, and it's not titled to you as husband and wife, then an estate's going to have to be open to transfer it to you, and the bank is probably going to require you to refinance it into a new mortgage in your name to purchase it out of the estate.
Okay. Yeah, I was wondering. I've been wondering about that.
Now, if you guys are, one thing that you could do at this stage, I mean, assuming that that's his intention to leave the house to you, et cetera, and that it's your, everybody's on board, what I would usually do is get you guys together, send you over to get it put into both names, and the bank may allow you to be added to his existing mortgage, or they may require a refinance, or while you're at it, we may shop you around and see if we can find you a better rate. I know some mortgage folks that might be able to help you out, and then what we would do is title the deed in both your names as joint tenants in the entirety, which would give you that special protection entitled to marital property. And it would also mean that upon death, the house would transfer automatically and wouldn't have to become part of an estate.
Okay. And is that, I know, it's a personal choice and all that, but would you recommend doing that, or just should I leave it the way it is?
I always recommend that parties, when married, jointly title the property with each other as tenants in the entirety, because that protects it against creditors. And so if your husband, for instance, comes out and runs me over, not only can I go after his auto insurance, but I can go after his assets above his auto insurance, which include his house. However, if it's marital property, I can't touch it. So it protects it from any potential liabilities out there that could occur that would be run just against him.
Right. And if somebody maybe was running a scam on him, and they could take his house, or he could sign it over to somebody, and I would have nothing to say about it.
No say, that's right. Or he could go out and encumber it, etc.
Okay.
So,
okay.
My usual advice is to jointly title it. All right, Mary?
Okay, thank you very much.
Thank you.
Bye-bye.
Bye. Okay, folks. So let's make sure you go to Weekend Appointment and throw your questions on there. I got a few I got to answer. I'll be putting answers up there. And let's see, who's next? Mike, you're on WHP 580 with Carl Rominger. Mike?
Hey, how you doing, Carl?
Good, man. What's going on?
Listen, I have a question. My wife works in a supermarket in Lancaster County, and when she was hired 10 years ago, they were on a 6-day work week.
Okay.
And just recently, they went to a 7th day, and she sort of opted out on that for religious beliefs.
Okay.
And they are really going after her about losing hours and sort of listing her from extra hours and sort of giving her degrading jobs that aren't related to what she was hired to do. And it's been a financial burden, and it's been a stress in the family. Do we have any rights with that? I mean, isn't that, breaking our constitutional rights?
Well, okay. Is she's saying she's opting out of that for religious reasons?
Yes.
The short answer is you can't discriminate on the basis of race or religion, but a policy, and I'm not sure about this, but I think a policy that's religious neutral, because if you say everybody has to work all the time, I think an employer can require that, and if they can't accommodate her, I don't know if they have to accommodate the religious request or not. Okay. But what you're saying is they have, but they seem to be retaliating otherwise.
Yes, almost on a constant basis, where people who've started, 3 months ago, as opposed to when she started 10 years ago, are getting, calls for new work. When somebody calls out, she's not getting called.
Right.
Other people are getting called a lot sooner than she is, and it's not really universal. It's a department thing. It's not a universal where everybody was required to do it because of where she was at. And they said she has to do it. So she could, basically name names and say, well, this person doesn't have to do it. And, and they'll say, well, that's in a different department. So it's really, it almost seems like they're handpicked her as a in particular.
The short answer is I don't know. I don't know if you can discriminate. In other words, if they're clearly doing it to her because of her religion, it's a problem. If, on the other hand, they're saying, well, since she's not the most flexible employee we have, we're going to give other people an additional leg up, so to speak. But it results in a discrimination to her, where they're just trying to edge her out. Can you do me a favor? Can you post this on weekendappointment.com so I can do a little research?
Sure, that would be great. Weekendemployment.com?
Weekend Appointment.
Oh, appointment. Okay.
Yeah, that's the name of our show, and it's also our website, weekendappointment.com. And if you post it there, then I'll remember to do a little digging on it, and I'll get you a better answer.
Okay, that would be great, Carl.
All right, man.
Thanks, bye-bye.
Hey, no problem. Yeah, folks, sometimes I can't answer them all off the top of my head, really. And that's an interesting one because I'm saying, first of all, can an employer discriminate on basis of religion? And the short answer is I don't think they can. But what about a policy of, we need you to be available 7 days a week? Well, which days? Last I recalled, some people have their Sabbath on Saturdays and some people on Sundays, and I'm sure somebody has them on Tuesdays out there. Larry, you're on WHP 580 with Carl Rominger.
Good afternoon, Carl. I have a situation that's probably unique for this program, but because it pertains to the juvenile system, it probably has applicability to many of your listeners.
Okay.
Here's the situation. We're a school bus driver. Last week of the school year, we had some money and property robbed by two of the students getting off our bus to the tune of in excess of $500. Now, we just got paperwork yesterday from the juvenile justice system, and one of the options for us is to request restitution. Questions are basically these. When we file the paperwork and perhaps request, to be, before the hearing and the judge, how can we make our case strongest that we not only request but demand restitution from the thief who took our material? Also, when we made notice of the incident, we listed 14 charges that we felt that students were guilty of. But the only one apparently that has been filed officially by the police department is theft of property.
Right.
Since the amount is over $500, it seems to us that this person is involved in grand larceny as well, which is a more serious charge, we would think. And can we add interest to the amount that was actually stolen from us?
Well,
for loss of that money over the period of time.
Let me back up and a couple side points here. First of all, ultimately the police or the prosecutor have discretion on what to charge.
Okay.
So if somebody's guilty of 15 different crimes and the government only wants to pursue one or none, that's their volition. So you can't really can't force them. There's no effective way to force them to do more. I mean, you could vote the district attorney out someday. You could, write a letter to the town board and ask the chief of police be removed, etc. But the reality is, what they're going to tell you is, we don't have the time, resources, or money to pursue everybody for every charge. Number two, they may say, listen, this is the juvenile justice system. We want to get these kids in here. We want to get him in probation. We want to get him help. But we're not here to punish him unnecessarily. Therefore, we're not going to heap it on the same way we might on somebody who commits a crime, when they're 35 years old.
Okay.
But as to restitution, you certainly should ask for the maximum amount. You should provide whatever evidence or documentation you could to show why that amount is what was taken. The biggest thing that comes up in restitution hearings is sometimes we're a little skeptical. The victim says they took 10 of my CDs and they're all $15 a piece. And you're saying, really? You paid $15 for all those CDs? Really? I mean, maybe you did, but we all know that you can now replace them, for $6-7 maybe, depending on what they were. So it's value of the items that were taken. Cash is the easy one to value. It's not necessarily what you paid for them back in the day, if that makes sense. So good proof of value is important. And the more credible it is, the more likely you are to be awarded it without any fight.
Okay.
Is that helping?
Given that the bulk of our loss was cash, we have no way to document other than our own credibility.
Right, and that's
how much we had in our pocket that day.
I would assume nobody's going to disbelieve you. But here's the thing: if you said something like, I had $2,700 in my pocket, okay, I might say, well, really, you were carrying $2,700 on you? And you would say, well, I was on my way to this antique show, and I'm an antique dealer, and it's a cash business, and these guys are all from out of town, and nobody wants my checks. And the judge is going to say, that makes sense.
Okay.
$400 or $500 amongst what? How many? Off of how many people? One person.
One person, actually. Yeah.
Yeah, that's not an unreasonable amount of money for somebody to be carrying around, such that we would just kind of question it.
Okay. And any opportunity to file in addition to the actual cash loss interest?
The short answer is, I guess theoretically, interest is available. Long and short of it is, I don't know most courts would award it.
Okay.
All right.
All right. Thanks, Carl.
All right, man.
Appreciate the insight.
All right, no problem. 540-0580. Carl Rominger here answering your legal questions. I'll take one more here before the break. And then, Jeff, I'm going to make you hold, buddy. Just hold on because we'll get Mark on during the break here. Tim, you're on WHP 580. Hey, Tim. Tim.
Oh, I'm sorry. I didn't realize it was my turn.
Yeah, you're up.
Okay, great. My son is having issues with a former landlord.
Okay.
It was an efficiency apartment, very small. Decided due to he couldn't find employment in Reading, was going to move down here to York with me. No problem. He went to give his landlords notice and also told them that they had the good fortune that if they wanted this person, a friend of his was going to rent the apartment. So there would be virtually no downtime.
Mm-hmm.
They got him to sign the lease. They did not get any money from him. Michael cleaned the apartment, moved down here. The guy decided not to move into his apartment, and now they're after Michael for rent.
Okay.
For this month. In his lease, which I have in my hand, the section that deals with tenant ending lease early, there are places in there where the landlord should have filled in X number of days notice, X number of days, X number of dollars for a termination fee.
Right.
Those are blank.
Okay.
What kind of legal leg does he stand on? Because they're sending him ugly text messages saying, "Cough up the money or we're going to court."
Well, I'd have to see the actual lease to check it out, but did he signed a lease saying he was going to take possession of it?
His friend signed the lease.
His friend signed it.
His friend signed the lease saying, he signed the same lease that Michael did when he moved in, but did not give them any money at that time.
Gotcha. And so now they want him to pay what the friend's supposed to
Now
pay?
they want my son to pay what the friend was going to be paying to rent the place.
Right. I would need to see the lease, but your son's out of there now, and somebody was substituting for him, and then they stiffed him.
Yeah.
Yeah, and we'd have to see, because I guess maybe the understanding was he was going to get a substitution and then move out.
I'm not sure that was the understanding. It just so happened that way. He gave him his notice before he told him, "I've got somebody to move in for you."
Gotcha. Well, I don't think he's responsible for the other guy unless, of course, he was getting out of his lease early with an understanding that he was.
No, they were on a month. He's on a month-to-month lease.
Yeah, then I don't think he owes him anything. But that's the short answer. Your son doesn't. The other guy might, because since he signed something.
Okay.
All right.
All right. Thank you very much.
540-0580. I'll see you after the break. Hey, welcome back. Carl Rominger here. 540-0580, talk line number. Mark.
Good afternoon, Carl. How are you?
Good. How are you?
Doing well, doing well.
So first of all, you were correcting me. Of course, I've started to mispronounce your name again. So I'm going to get it right. Say it for me once, and then I'll say it right.
It's Virginis.
Virginis.
There you go.
Say, I was lengthening it for some reason, but I was, as we were talking during the break, sometimes I'm Rominger, depending on how the judge feels about me at the moment. I've noticed the way they pronounce it seems to change.
You can imagine going through grade school, high school, college, how many professors and teachers got it wrong, so don't worry about it.
All right, brother. Now, I know you've got to give your little disclosure, so go ahead.
Yeah, I got one. I'm a registered representative offering securities and investment advisory services through Financial Network Investment Corporation, member SIPC. Mayor's Financial Partners and Financial Network are not affiliated. There you go.
And, of course, I give my disclosure right at the beginning of the show, so if you didn't hear it, folks, go back to the podcast and listen to it later, and you'll realize nothing you're saying here is privileged, and there's no attorney-client relationship created by us talking. So, and I got Jeff holding here, Mark. So I'm going to put Jeff up. I think, Shane, I accidentally just hung up on Mark. Can you bring him back here for me? Oops. Oops-a-daisy. Mark, I'm sorry about that. I was trying to put Jeff on with us. Oh, okay, Jeff, hold on a second.
All right.
Well, while we work that out, Steve, you're on WHP 580 with Carl Rominger. Steve, are you still?
Hello?
Yeah, you're here, brother.
Hey, I have a traffic accident question for you.
Yeah.
Okay. Now, what happened was, I think I still have you on speaker. Do I sound loud?
You do.
Okay.
You're good now.
There, we fixed that. How's that?
Good.
Whew, I'm working in my warehouse trying to get this call in. So, okay, what happened was, now, we're responsible for the accident, and since it was just a minor bump, I didn't go through my insurance company.
Right.
And it was one of my relatives was in my car, and I called the gentleman up, and he is insisting that someone professional fix his car.
Right.
Okay. Problem is, his car is 26 years old.
Uh-huh.
And it's as we would say, a beater.
Right.
Now, am I responsible to fix it in showroom condition or just fix it as it was?
Well, the answer is whatever the repair that needs to be done, if it needs a new fender or a new quarter panel, that's fine. If the rest of the car looks like junk, so be it. So you don't have to bring it back. And if the cost of repairing that might exceed the value of the car, or at least a certain percentage, I think 80% or something, then it's also a total, and then you're just responsible to replace the vehicle at its actual value.
What we're looking at is a part that I can buy and bolt on myself for $120.
Right.
Am I responsible to have it?
You got to pay. Let me put it to you this way: if you bump into my car, and if you're if you bump into my brother's car, he can put his own car together. If you bump into my car, I don't bolt nothing on my car. I take it to the guy down at the shop. And whatever the guy at the shop
into your Mercedes for nothing.
Well, no, it's a '98 Ford Ranger, all right, or Ford F-150, I should say. But my point is,
okay, the other car.
my point is though is I don't do nothing to my own car, so certainly he's not entitled to only be paid to do a home repair. He's entitled to the relative value of an actual repair by a professional repair person. Whatever that might be.
How about if I take the 4 bolts off and put the 4 bolts on myself? I mean, I'm a state licensed inspection mechanic, hypothetically speaking.
Right. So theoretically, that would be fair, but I think he's still entitled to go get a reasonable estimate. And if you guys can't agree, he can sue you, and the judge can determine what the fair value is.
Okay. Well, that's because I'm disputing with the size of the car that hit the vehicle that. I'm going to go. I haven't seen it yet, but I'm going to go take some pictures of it, and we go before the JP, correct?
That's right. That's right.
And it would be up to him to determine somewhere between my offer and his estimate, right?
That's correct.
Okay.
All right, Steve.
Okay.
Thank you, man.
Thanks a lot, buddy. Bye.
Bye. All right. Mark, I've actually got you locked now. I forgot to lock you the last time.
Not a problem.
Whoops. Okay, we'll get Jeff on with us here. Jeff, you're on with Carl and Mark.
Yeah. Hi, Mark. Hi, Carl.
Hey, thanks for holding and being patient through my my technical difficulties created by none other than my own index finger.
All right. Those things happen. Anyway, my question involves this the Roth IRA conversion that they're allowing this year.
Okay.
And whether there may be a better alternative that some people aren't looking at, because I was looking at that, and to convert, it's a lot of money. You have to pay tax up front, and on a fairly good size IRA, that's a fairly good size amount of money you're going to pay to the government right off the top right away. Correct?
Actually, this is the great year to do it if you want to do it, because you have 2 years to pay the tax.
Right, but it still could be, if you're talking in excess of $200,000, you're talking about good part of $60,000 that you're going to pay.
That's correct.
Okay, so my question is, I was looking at just different alternatives, and one alternative I came across, and I don't know how it would fit. If you have a 401k and there's a thing called a personal 401k, I understand you can borrow money from 401ks without paying tax on it, and you just have to pay the money back.
With interest.
With interest, right. But the interest you're paying based on interest rates is much less than the tax you're ever going to pay to the government right off the bat, and you're going to pay it basically as you remove it. So in one case, we're going to pay a whole bunch of tax this year, whereas if I converted this to, let's say, a personal 401k, which means any kind of money you borrow never has to be paid back because it's your 401k and you never get fired from you, would that save you a bunch of money over the long term?
Well, first, everybody's situation is going to be unique and different for those folks who are listening out there right now. But you have to also look at when you take actual distributions from that 401k, assuming over age 65, that's just a hypothetical, that's when you're going to retire, all the money coming out of that 401k is going to be taxed. Because I'm assuming here you're putting money in the 401k or the single or solo, or as you call it, the personal 401k. You're doing that on a pre-tax basis, correct? Hello?
He's still here.
Yeah, I'm still here.
Yeah. Are you putting that money in a pre-tax basis?
Pardon?
Are you putting the money into the personal 401k on a pre-tax basis? In other words, before...
Right, so it's all been pre-tax. Okay. So the IRAs are pre-tax right now, so no tax has ever been paid on them.
Okay.
And I'm just saying, in one case, you're going to pay all the tax this year, and then it accumulates tax-free, but you also have to pay that tax out of real... You can't just withdraw part of the money from the IRA and pay the tax on it, otherwise you pay a penalty, too.
Yeah,
so you have to have that $60,000 sitting around or borrow that money just to pay the tax. Well, and I'm saying, suppose I can create this personal 401k and use that as a long-term vehicle to reduce my tax bite.
Okay, there's a couple key things here. If you're self-employed or have your own company,
right?
You could,
and I'm saying, as somebody who has his own company, create a personal 401k.
Isn't there a limit to what you can put in that, though?
Not if I'm converting. That's the trick. If I'm converting from an IRA, I can transfer all the money to the personal 401k, just like you can from this, the Roth IRA. So it's not a matter of building it, it's a matter of transfer and saying, okay, as a long-term...
So all you're asking is, let me, because I think some of the listeners are going to go crazy here. All you're, Shane's like nodding his head, yeah. What you're basically saying is it cheaper to pay the interest on the loan against the 401k than it is to pay the tax bill? And the short answer, I would guess Mark's going to tell us, is that it all depends on how long you have to pay that interest for.
That's correct. I mean, I have Roth conversion calculation software that I run in my office for folks, because this is a common question, especially in 2010. Should I not Roth? And it gets into time that you're going to have it in the programs before you actually withdraw it. If you convert it, how long are you looking for? Do you want? I mean, for some folks who want a Roth IRA and take advantage of the law that it is this year, they're not looking to ever touch the money. And one of the nice things about a Roth is you never ever have to pull the money out of a Roth. You can let it sit there.
Right. You would never pay tax again on it.
Right.
Unless Congress changes the law.
That would be a big. That would be.
Yeah, that's always. But that's the same with your 401k too. I mean, I don't care what strategy you come up with. If they pull the rug out from underneath, guys, I got to go into break. Jeff, thanks for coming.
Okay.
540-0580. See you after the break. Hey, welcome back. Carl Rominger here, joined by Mark Virginis. Got it. Did I get it, Mark? I did. Okay. All right, let me see here. I got to figure out who's up next. James has been holding the longest. James, you're on with Carl and Mark on WHP 580.
Hi, Carl.
Hey.
I have a question for you. My 18-year-old son was at a friend's house.
Yes.
And they were drinking alcohol beverages. And the police came to the door. One of the kids let them in. They rounded up all the kids, gave breathalyzer tests, and they cited them for underage drinking.
Okay.
Now, we just received the summons and the citation in the mail. And my question is this a serious enough matter to involve an attorney? How long does this stay on his record?
It will theoretically stay on his record for life. He can eventually get it expunged after a number of years, and it will have driver's license consequences potentially. We know for a fact that when you're going to get a teaching certificate, it can cause you some difficulty. So generally we say, yes, you should involve a lawyer, and a lot of times we can either get it into a diversionary program so nothing shows up on their record, or we can sometimes get it dismissed entirely, and then other times we got to take our lumps, but there are a lot of issues in these underage drinking cases. For instance, did the police really have permission to enter? Did they seize people under the right circumstance? The mere fact that I have a beer cup in my hand and I have a youthful appearance may not give the police the right to detain me. So we win these quite often.
Oh, okay. So your advice would be to consult an attorney?
Yeah, it would be.
Okay.
All right.
Thank you.
Thank you, James.
Bye.
Yeah, folks, those underage drinkings. And the other thing is, you hate to think about it this way, but you might get a second one. And so the second one has even more teeth than the first. And if all you did was plead guilty dutifully to the first one, the other little caveat I always have, people drive me nuts when they just take their kids in and have them plead guilty because the smart parents beat the kid to heck in the woodshed, but keep it off the record. Rob, you're on WHP 580 with Carl Rominger and Mark.
Hey, Carl. How you doing?
Hey.
I have sole physical and legal custody of my 2-year-old and my 3-year-old. My son and daughter. We got that in November. My ex has not paid one dime in child support, although there is an order there. I'm not sure how she's getting away with this, but from what I hear, she claims that she's disabled and won't work, although she can.
Okay.
We have another hearing set up in the end of this month, actually. Is there anything I should prepare myself for? In order to, I'm just at a loss here how she gets away with this.
Well, the short answer is I would be prepared to argue that she should have an earning capacity assigned to her even if she isn't working.
Okay.
And I'd be prepared to investigate any medical evidence that she's bringing in to prove that. Now, if your hearing is just in front of a hearing officer and it doesn't work out to your satisfaction, you should appeal it and get it in front of a master or a judge where there's actually sworn testimony so that you can put her under oath and investigate what's really going on here.
Okay. Well, I appreciate that.
All right, man.
Thanks.
No problem. Let's see, and just so everybody remembers, Mark's our financial guru. So if you have a question involving, finances, the markets, and Mark and I are going to be talking about quite a bit about those things during the bonus podcast hour, which, of course, you can't hear live on the air, but you can call in for. So it's 540-0580 right now. And we keep the phone lines open from 3 to about 3:45, so you'll be able to call in with those questions. Andy, you're on with Carl and Mark.
Hello.
Yeah, what's going on, Andy?
Well, I've got an issue with a collection agency for what I think is a pretty small amount. It's about $315. What it was I made an overdraft on my bank of about $25. Did not get notification. I didn't know about it for about a month when the bank called me, and the bill was about $160 at this time from their charges.
Right.
So that was about 2 years ago. It got sent off to a collection agency, and they're after me, to collect the full $315 plus change. So my question is, I have to wonder if, are they actually going to take me to court? I very highly doubt they are, but I really want to, pay this and have it removed as a collection.
Right.
I'm trying to bring my credit score up. So, I mean, is there really much fear? And do I have, without a lawyer, can I get them to come down? I've offered them the 160. Explain that.
And they haven't taken it?
They said they'll take it for the full balance of $315 minus the interest that they're charging.
Right.
Which is like $60, $70.
Right. Well, the short answer is they don't have to settle, I guess, with you. And the long answer is you don't have to settle with them. But if the two of you can't agree on an amount, their remedy is to sue you. Right. But if you do nothing about it, it's going to be stuck there. And I don't think there's a way for you to force them to sue you. You just wait after the 4-year statute of limitations passes, then they can't collect it at all.
Oh, really? But they would still then remain as like an unpaid...
On your credit report, right?
Right. And that stays on for like 9 years or something like that.
Takes a while.
Yeah.
Mark, so any suggestions?
I mean, I guess I can just keep haggling and arguing with them and trying to get them to pay that. I mean, I guess if I were to be sued, I mean, can they sue me on all that interest?
Yeah, absolutely. And what I would tell you to do, I mean, bite the bullet. Pay a guy like me $45 or $75, depending on what an individual lawyer charges, to send him a letter with an offer. And last 10 times I've sent an offer letter to pay half of something, I've gotten it every time. So
really, yeah, I just didn't know what the cost of like a lawyer would be. I just assumed it would be at least a couple hundred.
I usually charge $75 to send a settlement letter like that.
Oh, okay.
All right.
I guess that answers my question.
All right, my friend.
All right, thank you.
Okay, let's see who we got next here. John, you're on WHP with Carl and Mark. John.
Hello.
Yep.
Hi. Sorry, I was distracted for a second.
That's okay.
I appreciate it.
What's going on, brother?
I got a quick question. I took a job selling windows for a small local company.
Okay.
And I'm doing very well. I'm selling, just to pick a number, $20,000 worth of windows a week. And he made me all kinds of promises that, I could be making $1,000, $2,000 a week at that level. But
right.
The problem is that he can't keep up with the installations. I only get paid when they're installed.
Right.
So if I sell...
John, you're going to have to hold for the... let me give you a quick answer.
Shoot.
The short answer is if he can't keep up with his promise, then you might have to find a better place to work. But what I do is try to figure out how to help him out and make those installs happen. I'm going to hold John for the bonus podcast hour. Folks, you can keep calling in at 540-0580. Now, all the phone lines are full right now. So if you want to call back in about 15 minutes, 540-0580, we can get you in. Otherwise, stay on.